the new world of information and new technologies in constitutional and administrative law. First, digital and the law. The attitude of jurists towards the new reality of the digital world is not very different from that of common people. As a matter of fact, their reactions oscillate between the following opposite poles. First, euphoria, consisting in looking to the digital as a miraculous solution to all the problems of mankind. This optimism towards the effects of information technology in human societies sometimes rushes in search of new utopias, like Alvin Toffler's Third Wave, in which the electronic cottages that our homes will become are seen as a global microcosm, a cocoon capable of solving all the political, economic, and social problems of modern societies. Corresponding to this, some specialists in constitutional and administrative law uncritically accept a total opening to the new world of digitalization in the field of law, always confident that emerging legal problems will be solved in the future by the progress of science. Skepticism towards information and new technologies, usually accompanied by technological ignorance and rejection. The digital is just a new reality in the world of facts, which has no consequences in the world of law. And the computers are seen as one machine more, a kind of sophisticated new typewriter machine, they say. These constitutional and administrative law specialists tend to say that there is no need for specific legal regulation for digitization and new technologies. There is no need for international principles or global standards on internet. There is no need to place the general principles of the information society or the new rights of digital citizenship in the Constitution. There is no need to specifically regulate the functioning of the public administration, nor to establish special digital procedures. There is no need to regulate legal action against administrative decisions taken by machines. There is no need to preview rules to allow challenging the algorithms or their use in front of a judge. There is no need. There is no need. In my view, both extremes of euphoria and skepticism are to be avoided. Rather, openness and critical thinking are needed to deal with these new phenomena. Information and new technologies are not a miracle recipe for all of humanity's problems, nor the devil on the roof. In fact, information and new technologies bring huge changes in the behavior of individuals, communities, political powers, with its advantages and disadvantages, challenges and risks, benefits and damages. All these transformations in the world of facts could not and should not remain outside the legal reality. It is time now, using a realistic approach, to analyze some of the consequences of information and new technologies in the field of public law. First, technological changes do have drastic consequences in the action of public authorities, of the legislative, the administrative, or the judicial powers. There is the work done by the machines acted by men, the replacement of paper documents by digital ones, the need to find out new digital procedures and processes in the decision-making process. In terms of the organization of the services, there is also a problem that should be considered. That is the mass production of court decisions, procedures, appeals. And the same happens with the mass production of deputies, administrative officers, lawyers, judges. This leads Belkin to question whether the government should adopt a factory model and whether is it possible to rationalize legal work without losing the human dimension, as Belkin says. Second, information availability. We are facing an indispensable tool for all actors and public services. As a matter of fact, the new technologies simplify the task of lawyers, providing an easy and reliable way to find status, law, regulations, court decisions. An easy way to make data research, information treatment. In a nutshell, we may say that we face a change in the behavior of all the law actors, the judges, administration, lawyers' offices, as Balkin points out. One could also pose the question whether is still there a place for law theory and philosophy, or if too much information could not come to the result of too less law. How to avoid that the banalization of the machines transforms their users into flesh and blood machines. 3. Specific problems arise from the use of information and new technologies in each one of the law fields. Just to point out some of the most relevant ones in public law, in fundamental rights, we have the right of digital self-determination, the right to access, to amend, to erase digital data, the right to be forgotten. In administrative law, we have the mass-produced administrative decisions, the authorization and the limits for automation, the digital procedures, the algorithms, and their administrative and judicial ways to control digital decisions. 4. Specific problems of law teaching. The use of information and new technologies is also relevant for law teaching and learning. Pedagogical tools like the PowerPoint, the web pages, the blogs, the video reviews, the long-distance lectures and conferences, the educational gaming, the electronic quizzes became well-known nowadays in all faculties and law schools. Especially during the COVID pandemic times, that are not completely over yet, the lectures were performed exclusively or mainly by video conference, and all the interactive digital ways of teaching were used in a daily basis. That shows very well the importance of a pedagogical approach more directed to the law problem than to the theoretical study of the doctrine, and more interested in discovering how to do it instead of how to solve it, as Ilma Felda pointed out. Digital and constitutional law. In this topic about digital and constitutional law, I will deal with 3 points, which are as follows. First, the constitutional theory approach. Second, evolution of the state model, the post-social state. Third, the new digital fundamental right. Constitutional theory approach. Technological changes require the renewal of constitutional law theoretical approach. Nowadays, the law actor needs to understand the change in the reality to be able to provide the right law to the case in question. We are living in a postmodern society characterized by industrial practices and mass production mechanisms, not only applied to material objects, cars, computers, but also to spiritual products like the law, the arts and music, the information and knowledge, and all kinds of services of the mind, as Balkin says. As in the past, it was impossible to understand modernism without understanding the Industrial Revolution. Nowadays, it's impossible to understand postmodernism without understanding cultural and technological changes. Therefore, a broader vision is demanded for law actors that should include a cultural point of view. The law actors need to understand law in the books as well as law in action. They need to combine values, principles, and interests with status, regulations, and facts. A multiplicity of approach is possible in this culturalist perspective. Peter Haberle sees law as culture, therefore he understands constitutional theory as a cultural science. and not just an economic and or social science. And he points out the necessity to understand both law and society, the culture of the law and the law of the culture, to make effective an open constitution for an open society. Different but complementary is the position of the legal critics, also called as critical legal studies or postmodern jurisprudence. White, Duzin, Warrington, McVie, Ward, Minda, Luderson, Levinson, Balkan. This current seeks to obtain the contribution of numerous other disciplines of knowledge for the correct understanding of law. In this effort to mix different science with the science of law, several combinations have been tested. Law as literature, law and justice as translation, law as music, law as performative art, and all other combinations. Personally, I already tried to combine law as culinary, as a recipe to understand mandatory and discretional powers as a cookbook, law as cinema, which is something that it's very important to understand problems of environmental law or constitutional law or other cases, law as psychoanalysis, like I done looking at administrative process law that are lie down on the couch of psychoanalysis. Nowadays, the demands arising from the transformations in the domain of information and new technologies force us to use new scientific disciplines, as well as the intensification of the recourse to the culturalist method under penalty of not understanding the current war trends. So we need also to study, among many others, media sociology. It is nowadays a relevant scientific approach to law and politics. As a matter of fact, there are huge changes produced by the media in the way institutions work. When you look to parliament, administration, courts, political parties, we attend first a movement from the televisions, from the newspapers to the televisions, as was indicated by Balkan. But now we assist of a new movement from the televisions to the internet, to the YouTube, the Facebook, MySpace, blogs, apps, Twitter, and all kinds of social media. And all these movements transform the way the speech is made and is spread out by political marketing, sound bites, law bites, fake news. If you look at the recent American episode after the latest presidential elections, the assault to the Capitol, we attend a mix of internet social media with live speeches, like the president's one, from political rallies, combining hate speech and fake news and appealing to the irrationality of mass behavior. We need also neurosciences. David Engelman studies the brain and applies it in digital tools to assess law decisions. He discovered that the brain isn't fully pre-programmed, but instead shapes itself by interacting with the world. This shows how our brains incessantly reconfigure their own wiring in a process that he calls live wired, applicable to digital tools. He runs the Center for Science and Law based in the University of Stanford, defined as an independent nonprofit institution, and he developed there, by this center, the neurocognitive risk assessment, a scientific tool to measure decision making that can be used to identify criminal offenders most likely to commit another crime, a very useful means for assessing courts in penal judgments. But we need also probability and statistics, more and more useful every day in the field of civil liability, namely in environmental liability and other risk situations. As a matter of fact, the theory of environmental law adequate causality cannot always mean the search of the remote concrete fact in a complex chain of causes, which may be replaced by a reasoning of probability and statistics to determine the predictable cause of the facts. 2. Evolution of the state model, post-social state and constitution. Information and new technologies also have consequences in the comprehension and the practice of the law, the constitution, the human rights, and democracy. In a nutshell, we need to understand, as Balkan says, how culture and postmodern technologies influence the law as an institution. In my view, we are now living in the post-social state since the 70s on. That is a constitutional response for the crisis of the welfare state, with the idea to increase the regulation instead of the self-production of goods and services by the administration. In the post-social state, the public powers try to regulate and to create infrastructures to fulfill public tasks with the cooperation of the individuals. The Infrastrukturverwaltung, as speaks Heiko Faber, another colleague from administrative law. And new fundamental rights are created in new domains of aggression of human personality, like in the fields of environment, the information and technologies, together with new procedural rights, the third generation of fundamental rights. After the first period of its implementation and the subsequent period where the state model had to deal with the financial crisis and impose the rule of the balanced budget, 2008, nowadays, after the COVID-19 pandemic, 2020, we can talk about a new period of the post-social state with a renewed tonic on the protection of the environment. The topic of the fight against the climate change became more and more crucial, and the expansion and the regulation of the digital in a safe and human rights friendly way. As seen as the two main finalities or goals for state powers. Together with these two main goals, also the public task of health protection after the pandemic crisis gained an essential constitutional dimension among the other state tasks. See, in Europe, the European and the national plans for recovery and resilience. Coming back to the question of information and new technologies, we must take in consideration both their individual and collective or social dimension. In fact, the digital world goes from the individual use of internet into the social media and the technological companies. And this double dimension brings increasing risks and threats to fundamental rights, to democracy, and to the Constitution. As Francisco Balaguer Callejon points out, there are many areas in which social networks have generated dysfunctions from a constitutional and democratic point of view. From fundamental rights to electoral processes, passing through the configuration of the constitutional order in a context in which the conditions of space and time have been transformed due to globalization and technological development, new cultural guidelines and new paradigms are emerging, and their impact on constitutionalism is very broad. We are facing now a global and multifaceted problem that requires law answers from all the sources and levels: international, national, regional, and local. From a constitutional point of view, this is a question that deals with global constitutionalism, European constitution, and national constitutions, and must be considered under a double dimension: an objective dimension, constitutional principles, goals, tasks for public authorities, and a subjective dimension, fundamental rights, human protection of dignity. As we said before, the novelty here is the emergency of constitutional issues beyond the states, as Cassese knows. It is the fact that formal distinctions between human rights and fundamental rights have been overcome. It is the attempt at building a global constitutionalism or a European constitutionalism alongside state constitutionalism. New digital fundamental rights. This area of fundamental rights shows the need to adopt a flexible and changeable notion in which the successive generations, following the evolution of the different state models, try to respond to the challenges and threats that human person dignity has been affected over time. As we just said, in the first generation of rights, born with the post-social state, information and new technologies, together with the environment and health protection, are not just the most fashionable constitutional values, establishing goals, principles, and tasks to state action, but they also give rise to new fundamental rights. The right to access to data, the digital self-determination, to data protection, the right to the environment, the rights of human protection in the fields of genetics and biotechnology, the procedural rights. Looking closer to the rights of information and new technologies, in the global constitutionalism, there is a charter of human rights and principles for the Internet, created by the United Nations Internet Governance Forum, a new international subject constituted by multi-stakeholders, governments, business, and civil society groups. In my view, this charter, no matter its formal nature and value, has a material constitutional content and already allows us to speak of fundamental digital rights without frontiers as implicit general principles of the international or global order, ready for application in private and public relations, as well as implemented and verified by administrative bodies and judges. In an alternative way, one may argue also that this implicit principle of rights for digital information arise from the deepest ethical values of the international community. Therefore, they are a part of the so-called modern version of the jus cogens. Therefore, or in another alternative way of seeing it, it's also possible to say that these fundamental rights are the result or are in the process making of an international customary practice as a repeated behavior with the general conviction of its obligatory nature and goes beyond the legal texts, even if it comes from them. It is not about a single constitution for the entire global legal order we are talking about here, like, for instance, Sabino Cassese. It is, however, the manifestation, as I used to say, of a constitutional phenomenon without frontiers, insofar as individuals are considered as subjects of the global legal order, where there is direct applicability of human rights norms to domestic legal relations, and where we have also subjective legal protection conferred by true courts constituted according to the international order, which defends citizens even against the actions and the omissions of their own state. What we are watching here are the phenomena of multi-level constitutionalism, distinct according to the regional, national, federal, European, and global level in question, as Ingolf Pernich points out. Or, if you prefer, questions of compatibilization of partial constitutions in the restricted domain of human fundamental rights at all the levels of the legal order, as Peter Heimler prefers to say. But at the European constitutional level, There is also the Charter of Fundamental Rights, and that charter enshrines the right to the protection of personal data, Article 8, that also includes the right to access and to rectify data and the guarantee of control by an independent authority. The European Charter on Fundamental Rights is a part of the European Constitution, at least in the material sense, although this does not mean that one can or should speak about a European state. Apart from the Charter, there are some other formally legislative texts with material constitutional level, establishing fundamental rights on information and new technologies, such as the Directive 2009-146 of the European Parliament and the Council of 25 November on the EU regulatory framework for electronic communication networks and services. The Regulation 2015-121 of the European Parliament and the Council of 25 November on open internet access. The Regulation 2016-679 of the European Parliament and the Council on general data protection. The directive of the European Parliament and the Council of 11 September on European Electronic Communication Code. And nowadays, the 2021-2027 long-term EU budget and Next Generation EU on the European Pact of Recovery and Resilience, in which the environment, the digital, and the health are considered as essential objectives of the EU. This is a part of the material European Constitution, and European that has not a formal form. It's not formally constitution, but from the material point of view, it's a real material constitution, and it obliges all the states that are obliged to apply this law, even against their constitution. Excuse me. In Portugal, the Article 35 of the Constitution enshrines fundamental rights in the field of information and new technologies. As a matter of fact, the original version of 76 was limited to establish rights towards manual archives, but it was extended to reach also the digital archives after the constitutional revisions of 1982, 89, and 97. The Constitution now established, namely, the right to access, to review, to update, to computer data, the guarantee of protection of personal data implemented through an independent administrative authority, the prohibition of using personal data unless legally authorized with guarantees of non-discrimination or for statistical treatment. The access by third parties is prohibited except in exceptional cases provided by the law. The prohibition of creation of a single national number, the right to access to public computer networks with the exception of personal data, and other rules. Lately, the law number 27/2021 of May 17, it was introduced a new instrument, the Charter of Human Rights in the Digital Age. Formally, it's a simple law, but materially, it has constitutional content. The law was unanimously approved by the Portuguese Parliament and immediately promulgated by the President of the Republic. The Charter was a good idea, but with implementation problems. Immediately after the vote, a lively discussion began in the media on the dangers of freedom of speech and state intervention in the digital, together with some criticism on the control powers attributed to the independent administrative authority for the media, considered not to be truly independent. And on July 29, 2021, the President of the Republic decided to send the Article 6 of the Charter to the Constitutional Court, invoking that there were problems of legal definition of concepts. There were uh, too vague and without the necessary densification. There were problems with the powers of the independent administrative authority, and was a problem of the fact-checking structures that are previewed by the law that should confer quality seal. It is time now for the Constitutional Court to decide about the constitutionality or unconstitutionality of the Article 6. Meanwhile, several norms of the Charter depend on subsequent regulation, which is now suspended. But perhaps we were going back in a very rapid way. We'll wait and see. Third part, information and new technologies in administrative law. A typical characterizing element of the post-social state in which we live in is the multiplication of administration decisions that result from the use of machines. From traffic regulation to tax settlement and the attribution of salaries and pensions, passing through the algorithms that determine the decision criteria, the phenomenon of administration through machines, as Werner Schmidt calls it, is increasing every day. Sorry, I had a cold. It's not COVID, just a flu that goes quite well. It's increasing every day. In the beginning, the first problem in this matter was to know how to make compatible the language of administrative law and the languages of the new technologies. The first solution to solve the problem of compatibility was the German theory of the two levels, Zweistufenlehre, that was theorized by Zeidler. It was based in the notion that there should be a separation between human activity of the public authorities and the mechanical one. The first being a legal activity that could be controlled by the judges, the second being technical and therefore could not be submitted to the law standards. In the discussion brought by this schizophrenic theory, the main critics were as follows. The emission of decisions by the computers is programmed by human beings, because the computers do not work by themselves. The accountability of the computer decision, therefore, is the accountability of the person working with the machine. So there should be no difference between the administration through the machines and the manual in this matter, from the legal point of view. Second, administrative law deals with decisions produced by public bodies. That is to say that the decisions are produced by a person in the use of public competences. So, the administrative decision is a fictional institutional decision, attributable to an authority and not to the person who performed it. Public decisions are not personal decisions in this sense, but decisions produced by persons and machines using the hats of a public body, as the American doctrine uses to say. From the administrative law point of view, it is indifferent that the decisions are produced by a computer or a person. The important is to know if they are legal or not. In a nutshell, we may say that legal standards are applicable to computer decisions as to person decisions using public competences or acting under the head of public bodies. On the contrary, the theory of the two levels was oriented towards the will of the administrative agents instead of the competences and the goals of the public bodies. On the other hand, Some of the concerns of the two levels theory were correct, mainly the idea of the need of a special regulation for administrative decisions produced by machines. As a matter of fact, there are specific legal problems of the administration through machines that may not be ignored, such as procedures for protection of the citizens. The administration by machines cannot mean an escape to the law. Therefore, it should have a special regulation for it, together with the application of the general principles of the administrative activity. Looking back to the problem of compatibility between law and machines, we should conclude that equal problems require equal treatment. Therefore, a computer result is an administrative act. A computer program is an administrative regulation, as very clearly says Peter Padula. The consequence of that conclusion is that administration by machines is submitted to general and special administrative rules in all the domains of substantive, procedural, and processual law. Regarding administrative justice, the novelty is that all the digital activity can be taken into a court. So there is a judicial litigation space for digital matters. Like in all others and in all other administrative decisions, an individual can go to court to ask for the annulment, the condemnation, or any other measure against digital action of the administration, including reacting against an illegal algorithm. In Portugal, the legal basis for the control of digital administrative behavior is the Article 268, number 4 of the Constitution, that enshrines the fundamental right to access the court in administrative justice, establishing the possibility of reaction against administrative action in a material sense. The constitutional norm determines the disregard of the form of the administrative action to allow its judicial control, which means that the digital behavior of the administration should have the same treatment given to all other administrative ways of action. However, in Portugal, there is a need for specific regulation on administrative action through the machines. If you look at the Administrative Procedure Code from 1991, in its original version, the situation was like this. On one hand, the Article 2, number 1 and 4, established that the general principles of the administrative activity are applicable even to the technical and digital activity of the administration. On the other hand, all the rules of the code were conceived to non-automated procedures, so it does not specifically deal with the problems of the administration by the machines. On the contrary, as it has been defended in Portugal by Professor Rebelo de Sousa, Dr. Salgado de Matos, and myself in different publications, there is a need for specific legislation in this field, and that's for the following reasons. Automation of the administration can collide with fundamental rights, and according to Article 18, number 1 of the Portuguese Constitution, the possibility of aggression of fundamental rights should be ruled by the law. Law should determine the field of application and the limits of automation in the public administration. And third, a special law is needed for special procedures, as in general for issues of form and procedure for the administrative action through the machine required. There was a reform of the Administrative Procedure Code in 2015, and it enshrines now some general principles in digital matters. Basically, the Article 14, named Principles for Government in E-Government. It establishes several principles like to promote administrative efficiency, transparency, proximity to the interested party, the availability, the access, the integrity, the authenticity, the confidentiality, the preservation, and the security of information, and more, a kind of a list of some principles that can be used here. It was a good step in the right direction, I might say, but it was not enough. Here are some problems resulting from this regulation. Some of the rules are not adequate nor effective. For example, Article 14, number 1 says the bodies in service of the public administration should use electronic means in the exercise of their activity. It does not say nothing. There is no rule in here. For that, we don't need a specific law. Second, the Administrative Procedure Code rules do not regulate any kind of digital procedure. We need, however, specific rules for specific digital procedures. The rules in question do not establish the limits of procedural digital issues for the protection of fundamental rights. For these three reasons, it's time to have a good regulation of the Administrative Procedure Code. It's time now to finish this article of the viewer review. I do it by making a wish for more and better legal regulation, both in the level regulation of of the digital world, both in constitutional and administrative law. We need it so much. Bye. It was nice being here with you.